May I please, your lordship?
Yes,
Lordship, with regard to item number 21, my lord.
yes.
My lord, this person was in bail, my lord.
Ah.
Item number 21. I have sent as many as 2 letters to him.
Ah.
And even I have tried to contact him his phone numbers also, but the address not found has been received. So my lord, I need some time to inquire to local advocate whether this person is alive or not.
Miss
S.G. Borua.
Learned counsel for the appellant submits that she has not been able to communicate with the appellant despite sending letters to his address.
My lord.
So, sir, she accordingly prays for time to obtain information as to the place of residence of the appellant and also as to whether the said appellant is still alive or not. List the matter after
My lord, yes, my lord, can it after vacation?
after with the vacation.
My lord. Oblige, my lord.
May I please, your lordship? Item number 22, lordship. This matter may come up next week, lordship.
Why?
Lordship, my senior DM Chaudhary, sir, he's not feeling well, lordship.
Is there any eyewitnesses in this case?
No.
Poxo, my lord. Child.
There
Oh,
wasn't any
okay.
eyewitness.
Poxo, only Poxo, child witness, difficult.
Lordship. For the day only, lordship.
But then haven't you heard, you must have seen the notification passed by court now, by the High Court,
Lordship.
saying that if you want adjournment, you
Lordship.
have to give prior
Yes,
intimation,
lordship.
then.
Yesterday, we were preparing the matter, lordship.
Okay,
We were,
okay. So he fell sick.
yes, today
Okay, right.
itself, lordship.
All right, on the prayer for adjournment made on behalf of Mr. B.M. Chaudhary, learned counsel for the appellant, who is reportedly unwell, lists the matter after a week.
Lordship.
Yeah, Your Lordship. My lord, with regard to item number 1 to 14, my lord,
Yes.
we are appearing in item number 4, 5, 6, 7, and 9, 5 matters. Out of the 14 matters, my lord. My lord, after the bail were granted in this matter to the evidence, they went back to their house at Manipur, my lord. After the paper books were prepared, we tried to contact with them to the instructing council. They were supposed to come, but because of the unrest, they were unable to come. We are awaiting some instruction whether
What do you mean they are unable to come? People are running away from there. Why can't they come? They want to remain there. Huh?
certainly because they have no other place. They are
What do you mean they have no other
permanent resident of
place?
that
Huh?
They are permanent resident of that place.
Huh?
They are permanent resident of that place.
What are they going to do?
My lord, they have to give the instruction.
What instructions? This is an appeal.
This is
What
a-
instructions is required? Everything is there in the records.
My lord,
What instructions do you need?
whether commissioner can appear,
Huh?
senior council, whether senior council can be engaged in this matter.
That is, you can always talk to them over phone, mobile. There is no ground for adjournment. There has been adjourned time and again, 2016 matter.
In the other matters.
In the other matters, my lord, I'm appearing. Of course, my learned friend, Mr. Vikas, he's shaping some 3 matters, 5 matters, and race again, I'm appearing. So, my lord, like this is for the last, since 2016, in between also. And we also gave a call and situation Manipur also not, and we need little instructions like whatever, any input.
What instructions do you need? This is an appeal, Mr.
But,
Counsel. All the records are there. You're not going to, you cannot adduce evidence. They are not going to
True,
argue
true,
in
true,
court.
but,
What are they going to say?
If your lordship is please, if it can be fixed after vacation.
No,
last
no,
adjournment.
why should we fix after vacation? Why? This is a matter, this is pending for so long. You cannot, you see, we are here to dispose of matters. And you cannot keep on adjourning once you have got bail.
The paper books were prepared only in the month of January.
Maybe January. So today is how many months? How many months do you need to read?
My lord, if your lordship last us after the vacation, then we will not seek any more adjournment.
Who is for the other side?
Mr. R.K.D. Chaudhary is appearing for.
So are you all prepared?
Decide whether they.
No, whether they are prepared or not, if they are not prepared, we'll carry on without them. Are you prepared? You're not prepared. Why? There is item 1 to 14.
1 to 14, Lordship.
Item number 2, madam. I think the matter, there's a matter, my lord, challenging, that is, professor, my lord. I think that, this item number 2, that has become infectious, but he can tell, I cannot do.
Yes,
Uh,
item number 2. Give me item 2.
my
You know,
lord,
this will be
they
subject
will say
to,
they are
subject to
appellant,
this appeal,
Yes.
subject to the outcome of this.
because that was with regard to forfeiture of property. That is all
Will be
been
subject to
done
this.
and the judgment has been pronounced with regard to that. So ultimately, it will be decided what happens with regard to the judgment.
Is the trial is completed?
Trial
Trials
completed. This
completed.
all these.
All these are appeals.
1 to 14 are
These are appeal, they're con-
against conviction, judgment matter.
So where are the records?
The records are here. in the station.
The records are here.
The paper books are prepared and given to us in the month of January this year.
No, it doesn't. Judgment was pronounced in 2016,
That is what,
and this matter relates to 2013. It is
no,
by-
you see that way, there are matters which relate to 2004 also we have got. That is not the issue. The issue is that this is 2016 matter. The appeal is of 2016.
Yes.
And these are a bunch matters. And it's a problem even for the registry to keep on hauling these cases around. So we dispose it of either this way or that way. We are ready. The appellants here are all on bail.
All are okay.
Our own bill.
That's why you are not happy.
No, it's not.
And
But a
My
lot
lord,
will be given because
I'm told, if I'm corrected, 2 of the appellant, they have sustained the whole period of conviction and they have gone out. 10 years.
Which one? Which,
That is- Madam,
item
they have not
12.
filed appeal, madam.
they have not filed appeal.
They have
Okay,
not.
they have not filed.
Yeah, they were happy with the conviction and that.
They are happy with it.
Madam, he's a chairman. He
I
is a
don't
chairman of
think they would have
UNLF,
been happy, but they accepted it.
Chairman of UNLF, and I think two, no.
Total 18 convicted. 5 are not convicted.
Huh?
Total 18 persons are convicted.
18, total 18
Okay.
were convicted
18 were convicted,
and only 14 has come before your lordship.
13.
13 has come before.
13 has come. What has happened to the other 5?
No, they are happy,
They're in jail.
they are happy.
So when do you want?
My lord, we are the respondent, we cannot say.
No, you can say, you fix a date, we'll give you a date.
That is in June, there is no, it cannot be completed. At least you will require 3-4 days or a week for the completion of the whole appeal, my lord. So in June, I don't find any dates, my lord. Definitely in July.
Okay. Okay, last chance. Third,
Nonsense for them, Madam.
Mr.
B Prasad. For item number 4, 5.
B Prasad,
B Prasad.
B Prasad, learned counsel for items 4, 5, 6, 7, and 9. And Mr.
MG Singh. MG Singh,
M.G. Singh, learned counsel for
The rest of the.
rest of the matters.
the rest of the matters, for the appellants in the rest of the matters. Come along with Mr.
DK Das,
D.K. Das, learned senior counsel,
State by
assisted by Mr.
Satyanarayana, and
Satyanarayana.
S. Narayan.
Yes.
S. Narayan. And
L Devi for RKD Kalura.
Huh?
On L Devi on behalf of
and
RKD.
L. Devi on behalf of Mr.
But she expired.
RKD.
R.K.D. Chowdhury, Deputy SGI. Pray for adjournment. And submit that they will argue the matter after the vacation. They also submit that they will not take any further adjournments. List the matter after the vacation.
Milord, item number 3,
Ah.
the appellant has expired during the penitentiary appeal. He was a patient also. He was released on
Then
bail.
we dispose of item 3. Any proof?
That has
Madam,
been
yeah.
recorded and submitted to lower court also.
Bonta, where is that?
Or I have to submit another death certificate, so far he is concerned.
No, so is it, if he is agreeable, if he agrees, it's okay, then we can dispose of.
Three, Madam.
Dispose of, okay, right.
There is no.
All right, Mr. M.G. Singh, learned counsel for the appellant, submits that the appellant in criminal appeal 169/2016 has expired on,
That too, I don't know, but during.
has expired in the meantime. Full stop. Mr. D.K. Das, learned senior counsel assisted by Mr. S. Narayan, appearing on behalf of the NIA. Does not deny the submission made by the counsel for the appellant. Full stop. In that view of the matter, the appeal stands abated.
All right, madam.
Appeal number 169/2016, criminal appeal number stands abated. Huh?
Well, this is a small matter, but respondent.
Small matter.
Respondent is not there. Respondent side. But we are the appellant here, Malad.
What is the matter about?
Malad, that is the critical, although it's an appeal, Malad, although it's an appeal, it's regarding bail that was granted by Dimapur Court, Malad.
Dimapur Court.
Dimapur Court. And I had
Bail granted when?
but a long time, Malad.
Bail granted when?
But that was 16.
2016,
2017, Malad.
2017,
17, 10, 2017.
17/10/2017.
Quite long time, Malad. But I'm not. The only difficulty is that respondent is not. I'm not with regard to because he happens to be a government servant. Malad. The only consideration was that, Malad, the learned trial court has not considered one factor which your lordship may like to, because while giving this,
The bail.
no, while giving, no, while giving the bail and this accused number 10, he wrote in a sheet to his assistant. that is pay 5 lakh to our and NPGK. That is a group, madam, to our. That.
That word, hour.
Oh, that-
No, that is a figure of speech. Good.
that that brings little closer than
No, you see, it depends upon how well, how good you are in the English in the English language.
yeah.
If you can, if you hear some of the submissions made by the councils also here, I mean, it's ridiculous. They mean something else completely.
Quite true, madam.
So how do you know that what as if he knows exactly what it means or what it says then?
Please, please arrange adjust to pay rupees 5 lakhs to our NPGK. That is a word that was used, and that is, that relates because we have got Supreme Court, they said that if it is not voluntary, payment is not voluntary, it's a question of extortion or by trade, etc. That is quite different. But when you do it by your own conscience, that becomes little different. So my only submission before Lordship, Malad, whether if your Lordship would like to send it back to Malad for reconsideration without disturbing the pay. That is all. This one.
What they
Yeah.
Let us see the order.
My lord, that your lordship will find at page 87,
Page 87.
87. My lord,
Yes, page 87.
bail application number so and so is being filed by so and so. They are all filed by their relative, my lord, for release of V. Aja, bail application of so and so, so and so. I may for release of A. Gutto Samai, bail application number so and so, for release of Kesoto Tapi, application number 6 for release of Purukanga. We are the last one,
Yeah, release of
Uh,
Puraku.
38717, so and so
Yes.
for Purukanga. We are concentrating. The instant bail application pertains to the same case and similar facts and circumstances. Hence, these instant bail application are clubbed together. So and so, so and so, so and so. The instant bail application are filed under so the learned counsel for the accused, so and so, so that the accused persons were arrested on so and so in connection with so and so. It was submitted that at the outset, the alleged accused persons are government servant and are no way associated with a terrorist organization, nor a member of unlawful affiliation. The accused persons neither solicit contribution or contributes assist to take part with the association nor raise fund for any terrorist act. The allegations are false and there is no probable evidence against them as such deserve to be released on one. The last concept submitted section so and so, so and so, so and so, madam, for application in the case of the alleged accused person in as much as the accused persons are in no way a member of unlawful association, terrorist gang or association or involved in terrorist activity. It was also more particularly submitted that the accused person has never raised or collected fund or provided fund to any terrorist group to commit terrorist activity. The learned counsel goes to submit that not admitting, but even assuming that the alleged accused person has paid forceful tax, not a forceful tax to the terrorist group. The alleged accused persons were under threat and intimidation, and it was a case of forceful extortion and not a case of raising fund for terrorist act. They never had any insurance. In order to support the continuous so madam, the decision has been relied on. Your lordship, next page 90. The
Just a
learned
minute.
counsel-
Please carry on reading in order to support.
Yeah. In order to support his contention, the learned counsel for the accused person made reference to judgment number of the Bombay High Court so and so, and the said application was alleged to have involved an offense punishable under section under various penal sections so and so, unlawful activities so and so. However, the bench decided at para 13 on careful consideration of the material against the applicant. There is not even an allegation that the applicant or any of them had at any time met any such person had and had agreed to do any illegal act. The applicants are not alleged to have handled any arms, weapons, or any explosive substance, or to have given incitement to commit any particular violent or unlawful act. And on such ground, it was held that the applicant cannot be denied bail. Therefore, the accused persons in the instant case also deserve to be released on bail. The learned counsel further referred to Guwahati High Court Sojam Rakhal field, so relied on para 15 and 16 and said the Honorable High Court which are quoted below, we are of the view that such an option cannot be formed at this stage. Only material available on record, as already mentioned, is in the form of statement of accounts in support of which there is no other evidence. The evidence of witness implicating the appellant in view of section 30 of the Evidence Act, the charge of conspiracy may not be sustained without specifying any particular offense of UNLF in which the appellant had conspired. In view of the above, without expressing any final view of the merit of the case, we are of the view that the case for grant of bail has been made out. The learned counsel further submits that all the 4 accused persons are medically not well as is evident from the medical records submitted by the NIA, hence deserve to be resolved. On the contrary, the learned special PP NIA submits that there are sufficient material in the case diary as well as the charge sheet against the accused person in connection with the present case to prima facie show that the accused persons are involved in connection with the present case. The accused persons had produced handwritten tax payment receipt paid to an unlawful officer, and the forensic report had corroborated that the signature and handwriting in the said receipt belong to the accused person. He further submits that the seized material shows the alarming situation prevailing in the state of Nagaland and practice of providing fund to fund in the form of taxation to the unlawful organization should be stopped. Tata Chinepapi also submit that in addition to the restriction for grant of bail under section 437, there is embargo on the grant of bail under section 443D of the UF Act. When the offense under chapter 4 and 6 are involved, the proposal of the said section further provides that the accused person shall not be released on bail if the court on a provisional case or the report made under section 173 of the code is of the kind that there are reasonable ground for believing that the accusation against the person is prima facie true. Hence, there is a prima facie case against the accused person. As such, the bail shall not be considered in respect to the accused person. Tata Chinepapi also goes on to object to the releasing the accused person on bail cannot be considered at this stage. Medical board has to be constituted in order to ascertain that the accused persons are medically fit. Moreover, the NIA and the jail authority can provide medical facility to the accused person if needed or necessary, and the accused person can avail medical facility under judicial custody. Hence, strongly raised objection for release the accused person on bail. In support of the question, the NIA relied on the following decisions, so and so. I have heard the parties on consideration of the parties. It is clear on record that the main issue before us is whether section 17 of the UFA under which the accused persons are charged may be considered as a record which is probably true, bearing the court from considering the bail application moved by the accused person. It is seen that none of the section 384 IPC, section 2 and section 1 of the Arms Act and section 30 of Drugs Act are applicable to the present to the accused person. Hence, we are considering section 17 and section 40 of the UAP Act as it is against the accused person, since it has been shown that the accused person has been paying tax to various underground factions. The fact that the accused person has been paying tax to different UGC faction is clear enough, as the learned PP of the NIA has brought before the court. Payment slip, and other related documents pertaining to payment of tax, which is drawn from the case diary. It is also clearly mentioned by the PP that the accused person have on their own volition produced the incriminating document to the NIA, and there is no record to show that the accused persons are belligerent to the process of investigation. This being the position, the difference which is mainly stressed upon by the council is that none of the accused persons are sympathizer to any of the unlawful organization, nor have they been paying tax at their own free will. This is cardinal position of the accused person, which have to be differentiated with the accused who are part of the organization and extortion money from various department of the government program. The other PPNIA has assiduously attempted to bring out that though the position may be that the accused are compelled by the UG faction, they have not resorted to make complaint to the concerned authorities, thereby desisting from using the protection of law enforcement agency from stopping this second. Hence, it is argued that by the latter PPA that the NI that the defense threat should not be made available to the petitioner for availing a portion of bail. I have considered the peculiar position which has a marked difference between the extortionists and the taxpayers who are under constraint. It is also in all correctness by the learned special PPNI to argue that the petitioners should take recourse to protection of the law enforcement agencies. However, in my considered view, the position of the accused who are compelled to pay tax are precarious, and there is no doubt that the law enforcement agency may not always be there for their protection and penalty and violation, which always loom is eminent. Under this fact, this given fact, we are drawn to the cardinal principle of criminal jurisprudence, which postulates that there can be no crime when there is no mens rea. It is apparent to see that the accused person have undoubtedly
Okay,
committed
so basically.
undoubtedly committed
He's
offense.
always referring to cardinal principle. Anyway, the fact remains that bail was granted.
And
Bail was granted, and it is also not denied by you that the finding of the court below that the accused persons have committed the offense due to element of threat is not denied, correct?
but
It's not denied. In your page 16, it is not denied. The above being said, now you want to set aside the
now,
order.
the only difference which I'd like to point out before Lordship is that this payment was done not voluntarily,
Yes, it
because
was not
when-
done voluntarily.
not voluntarily. When the slip, when the slip to please arrange adjust to pay 5 lakhs to our.
Where have you stated
No,
that?
no, the supplementary charge sheet was.
No, where is the, which is not here in your pleading.
That is where, my lord, the London trial court has not relied on this fact.
No, but have you pleaded that in your pleadings here?
These are charge sheet, my lord.
Supplementary,
not- I'm
supplementary touching.
But I have not vehemently putting this thing, but
And-
the only consideration that let us, at least some rule has to be followed. That's all. He is accused number 10.
So that's, this you do it during the trial, it's not here in your pleading.
That trial is going on.
Yes, Mr. Counselor, what is your case?
But trial has already started, my. I don't.
How many
Charge has
witnesses,
been framed by the,
how many charges has been framed? How many witnesses examined?
the witnesses were not examined, my lord, because, my lord, there is no special public prosecutor, my lord, appointed by the NIA, my lord.
No counsel
Yes,
appointed by
yes.
the.
They have not yet appointed any council, my lord.
But I cannot say, at least I don't. That must.
I have an instruction, my lord.
He may,
Anyway,
he
see,
in a better position to say that. but-
he has been on bail. since
One more,
October
that is
2007.
correct. From 17, from 17.
He's not running, away, he's a government servant.
He's a government servant, true.
And
He-
this,
Now he retired, my lord.
Only,
Now he retired, my lord.
now retired, and he's retired.
but only factor that I am only, that is the only sentence
So this aspect,
that
of-
our,
this
that our
aspect,
people,
this aspect can be taken care of during trial.
our people. Well, without considering it, let the trial court decide it. I do not, let him decide.
Who decide what?
Take into consideration this. Our people.
He's on bail, he's retired. And so many years have passed.
I leave it to your lordship. Alok. As I see the citizen from 17, he has been on bail.
Huh? Yes,
As I see the citizen.
since 18, 19, 20,
What a-
21, 22.
Without counting that is 6 years or 7 years.
In fact, has been 5.5 years, 5.5 years.
But
Something right. Heard Mr. D.K. Das, then the senior counsel, assisted by Mr. S. Narayan. For the petitioner. For the appellant,
yes, for that, no, yes, for the appellant and I am alone.
for the appellant, for the national investigation, for the NIA, for the National Investigation Agency, bracket NIA. Also heard Mr.
Islam.
Islam,
Islam.
Islam, learned counsel for the respondent.
Student number one, my lord. I'm appearing for student number one.
How many respondents are there?
Two respondents.
Who is number two?
Daughter of number
He has
one.
made particular, he was, he filed a petition, that's all. Madam.
No, number two has been, I think, has been deleted.
Yes, my lord. Number two has been created.
Madam, two has nothing to do, madam.
For the sole respondent, right?
No,
For the sole respondent,
Purukha,
for the sole respondent,
Angami,
Purakhu Angami.
Purukha.
This appeal has been preferred under section 21 bracket
21.
4 of the
And I,
NIA
Act.
2008 against the order dated 17/10/2017
Correct.
passed by the learned special judge,
especially,
NIA, Nagaland.
Right.
In case number R full stop C full stop 01/16/NIA GUW. Granting bail to the respondent, who was arrested on 13/10/2017. The learned senior counsel for the NIA submits that though he is aware that the respondent has been on bail for the last 5.5 years, that is from 17/10/2017, the supplementary charge sheet filed by the NIA in, what is that case number? Same case number, in so and so case number, the same case number. Contains the instructions of the respondent in his letter pad as Director of Tourism Department, which is to the following effect. Please arrange adjust to pay rupees 5.00 lakh to our NPG bracket K. Full stop. This has to be adjusted from SD civil work, inverted commas. Full stop. The grievance of the learned senior counsel for the NIA is that the use of the word inverted commas RNPG bracket K establishes the fact that the petitioner, that the respondent has sympathy and was inclined towards the NSCN bracket K, a banned terrorist organization. So accordingly, the bail granted to the petitioner should be set aside, as there was no occasion for the learned court, learned district court, learned special court to have granted bail in matters pertaining to section
Section
17. What is it?
17.
Huh?
20, 20, not 30. Matlab, section 20 and 30, matlab, 17,
17 and 30,
30.
17 and 30 of the NIA Act,
No, UAP Act, matlab.
Huh?
UAP Act.
of the UAP Act, sorry, of the UAP Act. What's up? Next para, the learned senior counsel for the NIA also submits that charge sheet having been framed, charge having been submitted, comma, charges have been framed
Frame.
against the respondent
Trial is going on.
and trial is going on.
Right.
First up, next para. Mr. T. Islam, learned counsel for the respondent, on the other hand, submit that the respondent does not have any sympathy or affinity with the banned terrorist organization and the alleged use of the word inverted commas R NPG bracket K comma does not establish the fact that the respondent has anything to do with the banned organization. So he submits that the payment should be section 17 and 40, not 30. 7. He submits that the payment of money to the banned organization is due to extortion made by the banned organization, comma, the refusal of which would have entailed great harm to the life of the respondent. Correct? I think it's. He also submits that the petitioner, that the respondent having having complied with the conditions imposed in the bail order, comma, there was no occasion for, there is no occasion for the bail order being set aside. Especially after the respondent was on bail for more than 5.5 years. Question. Question. Next para, the learned counsel for the respondent submits that though charges have been framed against the petitioner,
Against
no
the
trial has been
Against the respondent.
against the respondent, no trial has started before the learned special court in view of the fact that no counsel, no prosecuting counsel has been
Not correct.
appointed by the NIA to prosecute the case till date. Correct?
Yes, ma'am.
Next part. We have heard the learned counsels for the parties. The fact that money had been paid to a banned terrorist organization is not in dispute between the parties. It is also not in dispute that the respondent had paid the said amount prompted by an element of threat. This is clear from paragraph 23 bracket Roman 5 of the application submitted by the NIA, where it has held that the finding of the court below as so far as commission of offense by the accused persons, including the respondent accused, is correct, but the correctness of the existence of threat is neither pleaded by the petitioners in their bail applications, nor is it apparent on the face of the record. The learned court, the learned special court had recorded. No, the recording made by the learned special court, which has not been stated to be correct by the NIA, is reproduced as follows. Inverted commas, it is apparent to see that the accused persons have undoubtedly committed offense, but it is an offense which is prompted by element of threat. So you have not denied this. You have said this is correct, in fact. Next para. On in the first step. We have also noticed that bail had been granted to the respondent, who was the director of tourism department, government of Nagaland, on 17/10/2017. And that as on date, he has retired from service. Charge sheet has been filed and charge has apparently been framed against the respondent. Under which provisions of law? Huh? Charge framed under which provisions of law?
चला गया ना, group में चला गया। मतलब, it is supplementary charge sheet.
No, supplementary charge sheet can have a number of sections.
Yeah.
But which are the ones that will be framed?
All sections from supplementary sections.
All these have been framed. Have been framed under Are you sure? Under sections 384 IPC, section 25 bracket 1 capital B bracket close of the Arms Act, section 7 and 8 of NSR Act, section 13 of the Drugs and Cosmetics Act, and sections 10, 13, 17 and 20 of the UA bracket P Act.
My lordship, not much, the last para it is mentioned in the.
Okay,
agreement.
last
It's a-
para is mentioned.
Last recommended charge, those sections, not all sections.
Huh?
These the other few sections only again at this again.
That is what I'm saying. That's what,
In
we're-
Last para mentioned, not more sections. If the other accused persons are there convicted.
okay, so this was,
May I have, please, may, if not.
okay. In this charge, okay, charge under. No, he's ungoverned. Okay, only 39 and 40. that means.
Please, ma'am.
Okay, not all, huh? Only sections, charge has been framed under sections 39 and 40 of the UA bracket P Act. UAP Act is which year? 1967.
1969.
1967. First stop. The we are of the view that we are of the view that the question whether the words invert commas RNPG bracket K written by the allegedly written by the respondent in his letterhead, which is part of the supplementary charge sheet filed by the NIA. Establishes the respondent's sympathy and inclination towards the NSC and bracket K can always be decided during the trial proceedings before the special court. First time. In that view of the matter, and keeping in view the fact that keeping in view the fact that the petitioner has been on bail for more than 5.5 years. We are not inclined to, we're not inclined to interfere with the order passed by the learned special court granting bail to the respondent at this stage. The appeal, is the appeal? What is this?
Yeah, appeal.
And the appeal is accordingly dismissed. This is the portion, huh? You just look at this. Just give it to her now.
All right.
May I please your lordship? For item number 16, my lord, the engaged counsel, Mr. P. Upadhyay, my lord, is suffering from illness, my lord. He has also submitted leave of absence shown in the cause list also, my lord, till 18th, my lord. I'm not the engaged counsel, my lord. On telephone instruction, my lord, he asked me, my lord, and also officially, my lord, he has submitted. So after 18th, any date, my lord.
His name is not here.
My lord. In supplementary, my lord.
Huh? The supplementary list.
Yes, my lord.
Is there a supplementary list? I don't have any supplementary.
The cause list, I think.
That's why.
Supplementary costs, my lord.
Okay, there's a supplementary cause list.
Yes, yes. In that it has.
Okay.
Assigned, sir.
Okay, so we'll have to adjourn,
I am the amicus in item 17.
but what to do? It's together.
Any date, my
Even I was not informed, so I've gone through the matter. So it's okay.
okay. Oh, yeah,
I've
anyways,
also gone through the matter.
Huh?
I've also gone through the matter.
any date, my lord, after
It's
18,
okay.
because.
We'll do
Okay,
it
right.
on the next day.
On the prayer for adjournment made on behalf of Mr. P. Upadhyay, learned counsel for the appellant in criminal appeal 101/2020, comma, on the ground that he is not well, comma, adjournment prayer has been made on his behalf. Miss S. Jahan, additional PP, and Mr.
And
N. Deka, learned amicus curiae, submit that they have no objection. So accordingly, did this matter after?
After 19th, any date, my lord, any date. my lord. Yes,
20th, 20.
It's a Tuesday.
The Tuesday, man, of the-
This is a matter after the week. No date.
All right.
Babulali, no?
You are Mr. B. Prasad. Are you the one in this item 4?
Item number 4.
This
Yes.
NIA matters?
Yes.
You have taken adjournments there. And you are appearing here. What is this?
In that
You could not appear there. Why? In item 4?
As I told my lord, that we are awaiting instruction whether we can engage a senior counsel in the matter or not. It was not
2016 matter.
2016.
It takes you 7 years to decide whether you are going to engage a counsel, senior counsel. And this is a 2020 matter. And out here, you don't need to take any decision, is it? How many years does it require for you to take a decision whether you want to engage a senior counsel? Yes, tell us.
The appellant has been convicted under section 302 for life, my lord, with a fine of ₹1,000 and in default, 1 month simple imprisonment.
Yes, let us see the FIR.
FIR is at page 4, madam. FIR has been lodged by one Kalidas Bhumij.
Who is he? Prosecution witness number?
His prosecution witness number, my lord, 5. 6, madam.
1-1.
PW 6, madam.
Yes, PW1.
Here's PW1.
Yeah.
From where do you get 6? Let us see who is 6.
PW 6 is page 18, my lord,
18.
18.
Page 18. Page 18 is it is part of the evidence of the doctor or demonstrator.
Are we having the same file, my lord? Criminal appeal 100J.
104.
104.
I'm having 100.
No,
That
Babulali.
is-
It's carrying a wrong file. It is Babulali.
I'm extremely sorry. my
This
lord.
is Babu
I
Lali.
prepared
This-
the wrong file, my lord. I prepared the wrong. Extremely sorry.
It happens sometimes.
My mistake, my lord.
But you can take it up tomorrow then. No?
Tomorrow, the new list must have already been made.
It's a very small matter.
I know, I think there's
Small
all,
document.
I think there is eyewitness also.
Ah,
Eyewitness, everything is.
brother is there, father also came.
There's no
father was-
escape, in fact. So, there's no escape in this case. Right in front of their eyes.
Because of the two children fighting. He interfered and he killed. His daughter was also there, accused daughter. These are all poor persons, rickshawalas.
In the heat of the heat of the battle between two children,
Two children.
he entered the fray. Anyway,
Conversion will also be difficult.
huh?
Conversion will also be difficult in the fact situation. Let him go through and we'll do it next week.
Any demand.
Correct, on the pair of Mr. B. Prasad, learned amicus curiae who submits that he has inadvertently brought a different file. List the matter. Next Wednesday. That is on 14th.
What?
I apologize.
14th, I think we have already fixed one matter. Anyway, 14th.
Small matter, lordship will discuss. Oh, 19, I think Miss Meghali Burman and Miss Barnali Bhuiya both are there in court number 2, doing one
Okay, the
amicus
next-
matter.
We can do the next matter.
Yes, yes. Here, I think the juvenile issue is there. Because the accused seems to be juvenile.
Then,
Let
Yes,
her
well-
come, then lordship has to again call for a report from the
from the court
session judge.
sessions judge.
Even, I don't, it's so confusing that he was a juvenile. During the trial, it was known. But the trial judge did not go into that. He was 17 years. He was given in Jimma to his mother. But then trial judge did not go into this. A birth certificate is seized.
Anyway, you,
Hardly-
of the criminal appeal, this is in, huh?
Lordship.
Then, we are hearing you today.
He has filed an additional affidavit. Copy I did not receive, but I have gone through his copy. Lordship, on the ground, that the one of the accused person is 70 years old and she is indisposed. So on that ground, but that cannot be a ground, he cannot take that ground in appeal, in the final hearing, my lord. It will depend upon the merit of the case, your lordship. Age cannot be a criteria.
What is the case about?
A bride was killed, a lady was killed in a matrimonial home and her dead body was
Okay,
killed
wait,
inside.
today is for what?
Final hearing, my lord.
It's for hearing.
Yes.
So this application for early listing is of no
No,
use.
there is no application.
No, there is. This is
I-
an
I-
application.
I-
Seriously, ill, Lordship.
Huh?
That petition number 2, Lordship.
So you're not pressing this application for early hearing.
No, I'm eager to do the hearing, Lordship. But as so far as the matter is concerned, Lordship, I want to at first file an IA for this petition number 2.
Why?
Who is Lordship 70 years old, Lordship? I have.
Mr. Counsel,
Lordship,
let us be very clear.
Lordship,
You want to dispose of the case
Lordship is.
at the earliest?
Lord,
We'll dispose of the case today. You tell us. What is this? I don't understand your logic. You want to file a bail. It's on hearing. We are willing to hear you. Why, is it a bad case for you?
I
Eyewitness?
think
I case is not there,
circumstantial
Lordship.
evidence.
Ah,
Circumstantial evidence. Lordship.
Then,
Circumstantial evidence.
then if it's circumstantial, you have got a good chance maybe.
Maybe.
Huh? What do you think? On the one hand, you want Okay, let us be very clear.
Lordship.
Why don't you want to do, so you don't want to do the hearing today?
Lordship.
Why?
Because actually this is not good case for me, Lordship. And
It's not a case for you,
not good case, Lordship.
not a good case.
Good case,
Oh,
good case,
not a good case
Good
for you.
case. That is why I want to find an IA for release of this petition number 2.
So that you don't have to do the hearing.
I will do the hearing, Lordship.
So Lordship,
Then
may-
you see, then why have
after
you filed an
filing-
application for
Lordship-
early hearing?
Okay, that is correct, Lordship, but I want to dispose of this IL first, then I will do the hearing, Lordship. That is the thing, Lordship. Because I have the acquittal of this petition number 2, because I have annexed that document, additional affidavit, Lordship may kindly peruse the additional affidavit.
This is what, this is what is this case? Bright burning or what?
No, look, bright burning, 304, charges were framed under 304B, 302, 34 year lordship. But during conviction, 302, 34.
30234.
But within four, like the victim died due to 4 years of marriage. She is having 2 children. Circumstances that village people didn't see her, the locality people didn't see her, they came to inquire. This accused person gave false plea that she was not at home. Her husband said she was in Delhi. Then village people on their own, they have inquired, they searched for the victim. She was found inside, it was found in a Rani bag. The dead body was right.
And who are the appellants?
One is a husband, one mother-in-law.
Oh, mother-in-law is the old woman.
Three persons were there, one was acquitted.
Lordship, kindly go to the Lordship additional affidavit filed by me, Lordship, 107, case 107.
Additional affidavit filed by you? Where's the question of
Yes, taking
additional
the
affidavit?
plea of like her,
Huh?
one of the appellant is not well. She is 70 years old, but that plea he cannot take it up in the.
That is,
final
that,
hearing.
that is no ground. You mean to say, that is, where is your affidavit, additional affidavit? Anyway?
Record, Lordship.
Records. Let us see. And you just cannot file applications just like that. Yes, where is that?
107 page.
107, we don't have
107.
107. Acha, paper book or what?
Not paper book, Lordship, additional affidavit.
In the IA, is it the IA?
Not the IL. Lordship. That's the, that is why I want to file an IL for. Lordship. That is why I'm.
Yeah, what is the application? It's not even an application, it's an affidavit.
Yes,
To what effect?
to bring it on record regarding age and. age
To bring
band.
on record.
What's-
How does it matter? We'll accept that she's 70 years old, so what? So what does that,
That is, Lordship.
so what is the relevance of that?
Lordship, if Lordship gone to the judgment passed by the apex court, Dr. Dhananjay, Lordship, Rasidul Jafar, alias Chota versus State of Uttar Pradesh and Anandar.
So,
I want to read out one paragraph, one paragraph. The application for premature release shall be considered expeditiously. Those cases which have already been processed and in respect of which a report.
correct, Mr. Counsel, when the application is before the court, now you don't even have an application before the court. You see, we are ready to hear the main case. We'll dispose of the entire appeal. Now you want expeditious disposal of an application that you are going to file. While we are ready to dispose of the entire case today. What is the logic? Do you understand the irony of your prayer?
Lordship, I'm ready, Lordship, for hearing. I'll do that. Today, check.
Yes, yes, come, let's start.
Lordship, can you see this
Let us go to the FIR.
FIR, Lordship, that is. I'm reading out, Lordship, page 4, Lordship. Sir, humble submission is that about 8 years back, my daughter Deepali Vishnu was married of to above mentioned accused number 1 as per the social customs and traditions. At the time of marriage, clothes, utensils, and necessary wooden furniture were given to the accused as gifts. But accused number 1, along with his elder brother and mother, had been torturing my daughter, both physically and mentally, demanding dowry from her. around 8:30 PM on 16/5/2013, the accused person killed my daughter by making assault on her, packed her body in a gunny bag and kept it in the latrine situated behind their house. I therefore pray you to take necessary action upon investigating the matter and oblige. Yours faithfully, Sri Santi Mondal. Santi Mondal is the informant. Kindly see the Santi Mondal.
This Santi Mondal is PW number
That is good. I'm
9.
reading out Santi Mondal.
Please 31.
Page 31, page 31, Lordship. PW 9, Lordship. On oath, accused Sandan Biswas, who is present here, is my son-in-law. This is Dipali Mandal Biswas was my daughter, and she was the wife of accused Sandan Biswas. Accused Josna Biswas, who is absent here, is the mother of accused Sandan and mother-in-law of my daughter. Accused Prahlad Biswas is the elder brother of accused Sandan. About 3 years ago, now 4th year is running, my daughter Dipali Biswas Mandal died. About 4 years before the death of Dipali, I married her off to accused Sandan Biswas. 2 male children were born to them while continuing the conjugal life at Dipali. Accused Sandan used to torture her in various ways, demanding dowry. He had been torturing her by forcing her to bring money from my house. At the time of her death, Dipali Biswas Mandal was in the house of her husband Sandan Biswas. On the day of occurrence, some neighbors of Sandan Biswas informed me over her phone. On the day of occurrence, some neighbors of Sandan Biswas informed me over her phone that Dipali was no more and that her children were crying. Around 10:11 AM, I immediately came to the house of Sandan. I saw many people gathering in the house of Sandan. Accused Sandan Biswas, Josna Biswas, Prahlad Biswas, Dipali Biswas, and her children and aged person Singh by name lived in the house. Then the villagers and village headmen arrived there and they found the dead body inside a gunny bag in the septic tank, which was located behind the house of the accused person. Police was called. After arrival, the police and the villagers took out the dead body from the septic tank, which was kept in the gunny bag. When the gunny bag was opened, we saw the dead body of Dipali. I lodged an Azahar, which was written by a person of the village. Kindly see. I lodged an Azahar, which was written by a person of the village. I put my thumb impression in the Azahar. In the cross lordship, at the time of incident, I was in my house at Habergaon. The Azahar was written at noon. I do not know what was written in the Azahar. Accused Sandan Biswas is a handyman in a vehicle. He often remains in the vehicle. I do not know whether or not he comes from home at night. Accused Prahlad Biswas is a businessman. He has a shop. He lives at Utumari, which is near the house of the accused. I had visited the house of the accused many days prior to the incident. I did not see who had killed Dipali. When I arrived, I found the person, Singh by name. He was in the house of the accused person. I do not know where Sandan Biswas lives at present. I do not remember who informed me over phone that Dipali had died. When I went to the house of the accused, thousands of people gathered there. I do not know them. It was not written in the Azahar that the accused person had assaulted my daughter and had driven her out. My elder grandson lives with Sandan at present. Since after a death, I have not revisited the house of the accused except on the day of occurrence. I did not look at the injury on Dipali's body. It is not a fact that Dipali had an illicit affair with the person Singh by name and he eloped with him. After the death of Dipali, Sandan Biswas came to my house to bring back his children. It is not a fact that at the time of incident, accused Josna Biswas lived with Prahlad separately. It is not a fact that I did not state to the police that when I had gone there, the children of Dipali was crying. It is not a fact that I have lost case against the accused person on false ground. It is not a fact that the accused person never assaulted nor tortured Dipali. That is her personal lordship. In fact, that FIR was written by somebody else, and she only signed it, lordship.
How does that matter? How does it matter?
In fact, she did not know, lordship, what is written in the FIR. But she said that the doctor was
If a person who does not know how to write, how can she write? They'll ask the person who knows how to write.
But she specifically said in her FIR that my daughter was died on so and so. That is given.
They must have told him, did you confront her with any question as to whether the contents of the FIR were not known to her? Anyway, this does not say anything.
Right.
This does not prove anything.
Then Lordship,
PW9 evidence does not prove anything.
and the PW, Lordship, PW2 Lord, that is PW,
Let us go to PW1 first.
the first PW. PW1 Lord. On oath, I know accused Sandan Biswas, Prahlad Biswas and Krishna Biswas present here. This is Dipali Biswas was the wife of accused Sandan Biswas. I do not know if informant Santi Mandal is the mother of deceased Dipali Biswas as she hails from another place. The incident took place about 2 years back. I am the village headman of the Samaguri Bakbari village. The incident had taken place 2 days before I came to learn about it. This is Dipali Biswas was a member of Mahila Bandhan group. On the date of payment of the said group, secretary of the group asked for Dipali when Dipali was not found. The master of the Bandhan group asked the secretary to search for Dipali and bring her there. Then about 10 women of the Bandhan group gave a complaint to me that accused Sandan Biswas had killed his wife, Dipali, and he hid and hide her dead body in the latrine. Immediately I came to the house of Sandan Biswas. At that time, many people gathered there. Some foul smell was coming from the latrine. Watching here and there, we saw a gunny bag in the septic tank. Soon after I had informed the police about the matter, police, CRPF and circle officer arrived there. They also went close to the latrine and looked at the bag. Police lifted the bag from the septic tank. When police opened the gunny bag, the dead body of Dipali was found in sitting posture inside the bag. Many people gathered there. The circle officer prepared the inquest report. Exhibit 1 is the inquest report. Exhibit 1 is the signature as a witness. The gunny bag was seized. Exhibit 2 is a said seizure list. Exhibit 1 is my signature. Dead body was taken away for post-mortem examination. Police recorded my statement. Exhibit 1 and Exhibit 2 are my signatures, which was obtained at the place of occurrence. Place where accused Prahlad Biswas lived is about 2 furlong away from the main. That is the place of occurrence. Accused Sandan and his mother, that is Susna Biswas, lived together in the house in which incident took place. I do not know how the incident took place. I also do not know the date of occurrence. It is not a fact that I did not state to the police that women of the Bandhan group had informed me about the incident. A large number of this is cross-examination. A large number of people gathered at the place of occurrence. I did not state to the police that the police and CRPF person lifted the dead body from the septic tank. I did not state to the police that the dead body of Dipali Biswas was kept in a gunny bag. I did not state to the police that several people. I did not see Ranjit Biswas. Ranjit Biswas has been staying in a domestic help in the house of the accused for 10 years. I do not know Sandan Biswas does. That day, I did not see Sandan Biswas. Accused Prahlad came only after I had arrived there. It is not a fact that I know nothing about the incident. That is PW1, Lordship. And kindly see the PW2, Lordship. I know Sandan Biswas, Prahlad Biswas, and Rusna Biswas present here.
Read slightly slowly. You are reading too fast.
Lordship. The accused persons are our fellow villagers. Informant Santi Biswas is the mother-in-law of accused Sandan Biswas. This is Dipali Biswas, who is the wife of accused Sandan Das and a member of our Bandhan group. On a day of 2013, the incident involving the death of Dipali Biswas took place. Dipali Biswas was not coming to our Bandhan group since 2 weeks prior to the incident. She went to her maternal house. As she did not come to our group, even after her return from maternal house, the person of Bandhan group whom we addressed as sir asked our members to go to the house of Dipali, that is the house of the accused persons. Around 10 a.m., all the members, namely Basanti, Samulya Maya, Gwala, Sumi, Samulya, Rita Samulya, Padma Naya, and I went to the house of the accused persons. Arriving there, we inquired about Dipali Biswas. Accused Josna Biswas, that is the mother-in-law of Dipali, told us that Dipali had gone to her maternal home. We met both the children of Dipali. We asked her why she did not take her 2-year and 6-month-old children with her. Dipali took 10,000 from our Bandhan group and was repaying the amount in installments. We thought that she might be hiding at the backside of the house as she would not want to return the money. When we went to the search for her at the backside, we found the foul smell. We saw the manhole of the septic tank half open and foul smell was coming out of the septic tank. We saw a gunny bag inside the tank through the gap of the manhole of the tank. We called the neighbor. When people prodded the bag to show no, what was inside the bag. It seemed to be a human body inside the bag. People suspected the body to be Dipali. When village headman informed the PF police station, police came there. People gathered there. Police lifted the dead body. The dead body of Dipali Biswas was found there. We all saw the dead body. Police sent the dead body for postmortem examination. After observing all necessary formalities, police recorded my statement. In pros, the house of the accused is situated about 1-2 kilometers from our house. I do cultivation work on field. I cannot go to the work on the day on which meeting of Bandhan group is held. Prior to the incident, I did not visit the house of the accused person. Accused Prahlad Biswas lived in Putmari Sariali, about 7 kilometers from his own house. A boy Ranjit K by name had been staying in the house of accused persons. I do not know if Ranjit Mandal had an affair with Dipali. I have not seen Ranjit Mandal since after the incident. That person is eloped. That person has fled away, Lord. Ranjit Biswas.
Has fled away.
Fled away after the
And there was a foul smell coming from the latrine, but the mother didn't notice, no one noticed. Have you ever smelled a dead animal? It's quite overpowering. Even if it's a small rat also, it's in the road, its smell is quite overpowering.
Then Lord, I do not remember date on which I went to the house of the accused person. We found other people in the house.
Anyway, let us go to the next evidence, PW3.
Onward. I know the accused person present here. I know the informant Dipali Biswas was the wife of Chandan Biswas. The incident took place on 15/5/2013. Around 10:30 AM on the day of occurrence, I heard hue and cry in the house of the accused person. I came to the place of occurrence. I saw many people gathering in the house of the accused person. That is the place of occurrence. When I reached there, police were also there and they were opening a polythene bag. When they opened the bag, dead body of a woman was found in it. I saw that it was Dipali Biswas' dead body. I came to know that dead body was recovered from septic tank in the house of the accused person. Police seized the bag. I have seen that bag today in the court. Dead body was found in sitting posture. Exhibit 2 is a scissor list and exhibit 2 is my signature. In process. I am an elderly person in the village. I occasionally visited the house of accused persons. I saw the dead body in the Tiniali junction of 3 roads near the house of the accused person. Member of 2-3 families were present there. 4 police personnel were present there. I put my signature in the exhibit 2 scissor list at the place of occurrence. Police said that they have seized the articles and asked me to put my signature as a witness. Accordingly, I put my signature. I do not know what they wrote. Accordingly, I put my signature. I do not know what they wrote. Police kept the dead body on the bag itself. I cannot say about the length and breadth of the bag. Bag was stained with blood. I did not see any injury mark on the dead body. I knew this is Dipali Biswas. Police did not record my statement. It is not a fact that I have not seen the seized articles in the court today. It is not a fact that I have adduced false evidence. That is PW3. Then PW4. I know the accused person present here. I know the informant. I knew this is Dipali Biswas, wife of accused Chandan Biswas. Incident took place about a year ago. On the day of incident, when I was coming to the shop in the village, shopkeeper Budhimal Shah told me that someone he had killed Dipali Biswas and after putting her dead body in a gunny bag, kept it in a septic tank. Immediately, I came to the house of the accused persons. I saw people gathering there. Police was examining a female dead body. I also looked at the dead body. Dead body was Dipali Biswas. Police kept the dead body on the bag. The dead body was kept out from the bag. I have seen that bag in the court today. Police seized the bag. Exhibit 2 is a scissor list and exhibit 2 is my scissor signature in the scissor list. About 200-300 people gathered there. I saw people from some of the nearby village gathering there. I put my signature on being asked by the police. When I put the signature, nothing was written up there. Such bags are often available in the house of people. I did not see any blood. Police kept the bag open. I cannot tell about the size of the bag. It is not a fact that I did not see any incident. Then PW5. PW5 is the logic. Doctor says Dr. Narendra Bhagavati, who on 9/5/2015, I was discharging as SDMO at BP Civil Hospital. On that day, about 11:30 AM, I did postmortem of Dipali Viswas. Aged about 22 years, got from village. Bhagavati, Nutun Basti, Thana Samuguri, Noga Assam, as per police inquest number, Samuguri PSC 472, dated GD number 472, dated 18/5/2013, escorted by WPC C11. Stroke 1147. Sri Dipali Viswas, Sri Pradeep Mandal, and Sri Krishna Das. Escorted by WPC, Sri Dipali Das, Sri Pradeep Mandal, and Krishna Das. Then Lordship, this is the all medical things he has been written. Lordship. He is a doctor. He did the Lordship postmortem report of the deceased. Postmortem of the deceased. Then Lordship PW6. Then in cross Lordship, this doctor adduced evidence that the injury may be caused due to falling on hard substances in cross. I have not got any other injury on her body. I have not maintained any registered book against the postmortem report. Then PW6. I know the accused person present here by their name and faces. The accused persons are our neighbors. I do not know informant Santi Mandal. This is Dipali Viswas was the wife of accused Sandan Viswas. The incident took place about 2 years ago. Two sons were born at Sandan to Sandan and Dipali. At the time of Dipali's death, the elder son was 5 years old and the younger was 4 months old. Since after the marriage, Dipali had been staying in the house of the accused, that is her husband, Sandan Viswas. Occasionally, quarrel took place between Dipali and Sandan. Incident perhaps took place on the Thursday of the week. In the morning on Friday, when I heard Dipali's younger son crying, I came to the house of accused and I asked Jyotsna Viswas why baby was crying so much. Then Jyotsna Viswas said that his mother, Dipali Viswas, had left the house and she did not know where she had gone and that the baby was crying owing to that. Around 10 AM on the following day, that is on Saturday, the women of Bandhan group came to Dipali's house to know why Dipali did not go to the work. The women searched for her and they found the gunny bag in the septic tank on the back side of the house of the accused person. Then they called a couple of boys from the neighborhood and showed them the latrine. Then they removed the lid of the latrine septic tank. They saw a gunny bag, the mouth of which was found closed and it contained some heavy stuff. Then the village headman, Bhadra Rabha, was informed. The village headman then informed the police. The village headman had informed the police after he had arrived there. Arriving there, police lifted the gunny bag from the septic tank. When they opened the gunny bag, they found the dead body of Dipali inside it. Many people gathered there. Dead body was sinking. Police took away the dead body of the postmortem examination. Police recorded my statement. My house is situated at a distance of in Cross Road, it is stating. My house is situated at 1 2 feet from that of the accused. Many people gathered at the place of occurrence. People from the nearby villages were also present there. At that time, Kamal Sandelya, Raghu Sandelya, Daya Nayak, Ratan Bari, and others were present there. I saw the woman. I went to the house of the accused persons. Police did not question me regarding the incident. The village headman also did not ask me anything. I do not know how the dead body of Dipali entered the septic tank. I do not know how Dipali died. It is not a fact the dead body of Dipali was not recovered from the septic tank. It is not a fact that dead body of Dipali was not kept in a gunny bag. It is not a fact that women of the Bandhan group did not come in search of Dipali. It is not a fact that when the baby was crying, I did not ask Jyotsna anything regarding it. It is not a fact that I did not see any quarrel taking place between accused Sandan and Dipali since after their marriage. Then PW7. I know accused Prahlad Viswas, Sandan Viswas, and Jyotsna Viswas present here. I do not.
So basically, everything is the same.
Okay.
Now, come to page 39. Who is this person? Deposition of EOI, what is
Investigation
EO1?
officer.
Executing
Ex-
officer,
Executive.
Executing officer.
executing officer, he
Executive.
went to give summon and all that.
Huh?
He was went to give summon. I working as ASI Samaguri,
Huh.
PNA issued.
PNA issued.
Okay.
PNA was issued against Ranjit Biswas.
Who is Ranjit Biswas?
He is one of the relative. No?
Relative.
He was one of the relative of this project,
Relative of the appellant.
appellant project. And he is staying there for last 10 years. Project.
Staying where?
That in their family. Lot.
In that family.
In their family, and when the offense took place, that incident took place, Lord, thereafter he pleaded away. On the second day, he played away.
He fled away.
Played away, Lord. He should have an affair. He must have most probably he have an affair with that Dipali Biswas.
We do not know, maybe,
don't know.
but then that does not give you license to kill.
Right.
Okay, you see, he could have taken the plea that I saw them in a compromising position. And due to grave and sudden provocation, I killed or something like that. But that is not the, I think nothing of that sort has been stated.
That is correct, Lordship, but Lordship is aware for love affair. Such type of incident took place now also.
But then where is that? Where is the
There is
suggestion?
there is no direct evidence. Just I'm stating, Lordship.
That is
Maybe.
that is conjecture, you are speculating something.
Because why he should plead away? He should have stayed.
We don't know. We do not know.
Suspicion arises, Lordship.
Yes, but suspicion cannot take the place of proof, no?
That is correct. In the PID was issued against him. On 27th, PW, EO1. 27/6/2014, I was working at an ASI, a Samuri PS. That day, the OC enrolled the PNA issued against Ranjit Biswas to me for execution. I went to the house of the.
Let us see the 313 statement.
Page 41, on the page 43,
Page
43. Continue from page 43. No plea, my man.
Denied, Lordship.
complete denial.
Complete denial, Lordship. Complete denial.
Okay, now. You see, one issue is. How did the body land up in your latrine?
That is the question we are certain.
That is the big question.
Big question, Lordship.
And people usually, if they, you see, usually, supposing you kill somebody, you try to hide it. And then you are hiding it in your latrine.
That is not proved, Lordship, because I was at that time of occurrence, I was there. I and my mother is there, but there is no witness.
There's no witness, but you see, those persons, those ladies came, number of them, around 10 of them came. They said, where is so and so? You said she has gone to her maternal house. Earlier you said she had gone to Delhi. Then you said maternal house. And then they found it in the latrine. The outsiders could see that it was in the latrine because that latrine lid was open slightly. Then
Half open.
difficult uphill task. We'll take it up after lunch.
Fairly covers Trimukh Marty Kirtan's
Huh?
case. Trimukh Marty Kirtan's case that has committed inside the house, no explanation from the inmates. He admitted they were there. There would have been an explanation from their side. Covers your shall side the judgment.
They
I
bring
was
the
there,
judgment.
But it does not mean that I
Huh?
killed her. I was there at the time of occurrence when this incident took place, Lordship. No doubt I was in the house, but
You did not know about it.
so I did not know about it, Lordship.
But outsiders could come in and
Outsiders-
immediately find the body.
What?
But
Gave
you
false
living in the body in the house, you could never find the body, though she had died for 3 days.
And false explanation given to the
And another
neighbors.
thing, they have 2 children. How old are they?
6 months and
And
Six.
5 years.
One was
5 years.
four-
One,
huh?
One is 5 years.
5 years.
that's good.
One is 5 years and the other one is
6 months,
6 months,
6 months,
3 months,
6, sir.
6 months.
6 months.
The 6 months old baby, they need milk and they need their mother. And is it conceivable that you would allow your daughter-in-law to go to her maternal house alone for 3 days without taking the children?
that is important aspect of it.
Difficult. We have gone through the 313. There is nothing in the 313, no explanation given or blanket denial. So the death was caused due to ligature? No,
No, your
due
lordship,
to the
your lordship, kindly see
skull,
the doctor,
skull.
PW, yes, injury on skull, PW5, your lordship.
page 20.
Cause of death was due to shock and hemorrhage as a result of head injury leading to coma. The injury may be caused due to falling on hard substances. I've not got any other injury on her body.
There is no weapon recovery, nothing. So they are not saying anything.
So I want to place some decisions,
Yes, yes.
place some decisions, Lordship, next week, Lord.
No, 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 no. What do you mean next week? What do you mean? Why next week?
Not available, Lordship. only
Huh?
Not available with me last, right?
Today is the day for hearing.
Next week I will definitely place it, Lordship. Those last.
To what effect?
So regarding circumstantial evidence, Lordship.
Circumstantial evidence. There are so many. The general circumstantial evidence, I will place it for you if you want.
May I strike on judgment, you know.
You have got to mold, you see, the citations have to be in support of your submissions.
Lordship.
So what are your submissions that you want to be support, that requires support? You please tell us that. What is the circumstantial evidence or the lack of it that is going to be supported by the decisions that you are going to produce?
Really, what is Lordship? When there is no direct evidence, Lordship. What the circumstances at that point of time, when on the date of occurrence, that will prove the guilt of the accused person, Lordship. That is the circumstantial evidence. At that point of time, nobody is in the house. Only me and my mother is there. So in this case, circumstantial evidence will prove my guilt.
The body, the person had been dead for how long when it was found, as per the post-mortem report?
Prior to 1805, yes, time since death is there.
3
Page
days,
74, page 74.
3 days prior to 1805,
Yes,
page 21. Last line,
yes.
last 3 lines.
3:30 AM, prior to 3:30 AM of 1805.
And 3 days prior to 1805,
1805.
as per inquest report.
Yes.
Okay, what is your submission, madam?
Lordship, he admittedly made his submission the day these two accused persons were at home, your lordship. Doesn't deny that. They
They
were,
were at home,
they
yes,
were at
they were.
yes. They gave false explanation when the other neighbors came searching for her.
Now those ladies went.
Yes,
Hmm.
they lied to the public, your lordship. Then, your lordship, as per the evidence of PW7, they did not allow the neighbor to enter. As per the evidence of PW8, false information given to the public. Those are the
Just a minute.
circumstances. If the lordship considers evidence of PW2, my lord. Page 14, my lord.
PW,
PW two, page 14.
yes,
Relevant question, second line. Accused Jyotsna Biswas, that is the mother-in-law of Dipali, told us that Dipali had gone to her maternal home.
maternal home,
We
yes.
made both the children of Dipali. We asked her why she did not take her 2 year and 6 months old children with her. Dipali took rupees 10,000 from a Bandhan group and was repaying the amount in installments.
Yes.
We thought that she might be hiding at the backside of the
So
house.
luckily you had nosy neighbors and nosy
Yes, yes.
uh,
Then, my-
persons
yes,
who were bent on finding her,
yes,
thinking that she was hiding
yes.
to avoid paying the money.
Then, my lord. Yes. Evidence of PW6.
PW6, yes.
Yes. Next line, my page 24. Jyotsna Biswas said that his mother Dipali Biswas had left the house and she did not know where she had gone and that the baby was crying owing to that. Then my lord, evidence of PW,
Yes, yes, all this evidence
my
is there.
lord, it goes against them, my lord. Lordship and I want to rely on one judgment, 2006 10 681,
2006, 10 SEC,
681.
681.
Trimukh Maruti Kirtan, was the state of Maharashtra.
Para,
Para 12, my lord, may I read? I have given the
yes.
lordship. Para 12. Page 689,
Para 12,
my lord.
yes.
In the case in hand, there is no eyewitness to the occurrence and the case of the prosecution raised on circumstantial evidence. The normal principle in a case based on circumstantial evidence is that the circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established, that those circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused, that the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused, and they should be incapable of explanation on any hypothesis other than that of the guilt of the accused and inconsistent with their innocence. Then your lordship, para 14. If an offense takes place inside the privacy of a house, as your lordship got it, my lord. And in such circumstances where the assailants have all the opportunity to plan and commit the offense at a time and in circumstances of their choice, it will be extremely difficult for
Yes,
the prosecution.
106,
Yes.
section 106.
106, yes. No explanation. Para 14, 15, 22, and rely.
I want to place one on judgment lordship. Gagan Kanojia and another versus state of Assam, Punjab, 2016, 13 SSC 560.
2016,
2006,
2006,
13 SSC 516.
13 SEC 516.
May I read you?
Yes, yes, please.
The prosecution case is based on circumstantial evidence. Indisputably, charges can be proved on the basis of circumstantial evidence, even when direct evidence is not available. It is well settled that in a case.
Para, which para is that? Paragraph?
Paragraph, lordship, I'm just reading this. That is why I'm guessing. Saying before
yes,
lordship
yes,
to place
yes,
the
okay.
last one.
Okay.
Just ask, I'm reading lordship. It is well settled that in a case based on circumstantial evidence, the prosecution must prove that within all human probabilities, the act must have been done by the accused. It is however necessary for the court to remember that there is a long gap between may be true and must be true. Prosecution cases required to be covered by leading, cogent, believable, and credible evidence, whereas the court must raise a presumption that the accused is innocent, and in the event two views are possible, one indicating to his guilt of the accused and other to his innocence. Defense
When two views are possible.
two views are possible. Whereas the court must raise a presumption
So
that
the view favorable to the accused should be taken.
he is innocent, and in the event two views are possible, one indicating to his guilt of the accused and other to his innocence. Defense available to the accused should be accepted But at the same time, the court must not reject the evidence of prosecution proceeding on the basis that they are false, not trustworthy, unreliable, and made on guilty ground, or on the basis of surmises and conjectures. The prosecution case thus must be judged in its entirety, having regard to the totality of the circumstances. Approach of the court should be an integrated one and not truncated or isolated. The court should use the yardstick of probability and appreciate the intrinsic value of the evidence brought on record and analyze and assess the same objective. Then another is there also remove Maruti Kirkan versus State of Maharashtra, 2006, 10 SSC 681,
Eight SCC.
2006, 8 SSC.
That is
10
the judgment
10
I have
SSC.
already cited. Remove party.
2008 SCC page.
Page 681. 681.
No, he 10 SCC should be not 8
10
SCC.
10 SSC
Huh?
68, 10 SSC 681. 10
Same,
SSC,
okay, same, okay.
10 SSC.
Which para?
This is 12.
She cited.
He cited.
Yeah, she is citing in your favor.
And another logic. 1996, 10 SSC, page 193.
Huh?
Sengar Reddy versus State of Andhra Pradesh.
Citation
1996, 10 SSC,
8 for 8.
10 SCC.
10
10,
SSC,
10.
page 193, paragraph 21.
Paragraph
21.
21.
In a case based on circumstantial evidence, the settled law is that the circumstances from which a conclusion of guilt is drawn should be fully proved, and such circumstances must be conclusive in nature. Moreover, all the circumstances should be complete and there should be no gap left in the chain of evidence. Further, the proved circumstances must be consistent only with the hypothesis of the guilt of the accused and totally inconsistent with his innocence.
So you appear to have all the citations.
Here I will paste. Okay, I'll paste.
No, don't have to place. We'll find it out. You have given us the citations.
Okay.
We have marked, we have recorded it. We will take out the book ourselves. No need of wasting paper. That's all. So your basic case is that your basic case is what? What is the basic argument or your submission?
Submission is that logic, circumstantial evidence. No one is, I and my mother in my own house. And my wife dead body is found in the septic tank. I'm ignorant of that. When people,
You're ignorant of that.
ignorant of, and people came, they brought the foul sand. They come to know that something is in the septic tank because septic tank cover is.
Okay, so that, so your basic case is that you did not know that the dead body of your wife was in the septic tank.
Septic tank.
That's all.
And another thing is that one Ranjit, one Ranjit Biswas, who is one of the relative of one of my relative, he stayed in my house for last 10 years.
And he ran away.
And he hid away after incident.
When did he
after
when did he
when
run
dead
away?
body is recovered from the septic tank.
Ah,
On next day, he hid away.
where is that evidence?
Evidence project there's, it is like that.
Where is it that next day he ran away? When did he run away? Meenakshi, one item we have listed, I think Miss L. Jahan's case, simple matters, it's Wednesday, we have to shift it to Thursday.
Lordship, page 14.
Place 13 maybe produce 37 run.
Boy Ranjit by
Page,
name,
page,
page 14.
Page
madam.
37.
37, let us see 37.
At 5 p.m. I received the Izahar was written by someone. I did not examine the person who was written as I submitted a charge sheet showing the so I submitted a charge sheet showing accused Ranjit Biswas as conduct. Ranjit Biswas lived in the house of Sandan Biswas. Ranjit Biswas is not a member of the family of the rest of the accused person. He was in the house of the rest of the accused person, but later he fled from there. On 19th day of
19th.
month, I arrested the accused person's witness.
Huh?
He was in the house of the rest of the
Page
accused person.
30,
38, that 37, then 38. Lordship. Ranjit Biswas is not a member of the family.
so when did he run away? There's nothing,
Lordship, no, it's there on, played from there on 19th day of month.
19th of March.
It's a evidence of IO, but PW2 also says that, my lord. PW2, page 14. Accused Josna Biswas, that is a mother-in-law of Dipali, told us that Dipali had gone to a maternal home. So and so, not this one, just a minute.
Then page 27, Lord.
The incident occurred in May
Yes,
2013. So he fled away. The date of fleeing away, where is it? On 19th?
page 38, my lord. Played from there on 19th of, played from there, but date is not there, my lord.
That's what. When did he flee?
Kindly peruse Lordship, page
Huh?
27, page 27, Lord. Page 27.
Yeah.
PW7 witness,
Yeah.
his cross examination, Lordship may kindly say, page
Yeah.
27. The house of the accused person is situated adjacent to mine. We are
He disappeared after the incident.
visiting by a boy by the name of Ranjit Biswas had been staying in the house of the accused person. He disappeared after the incident.
After the incident.
After the incident. he
And what is date is the incident?
18/5 is the FIR.
18/5/2000.
So he disappeared after 18/5.
18/5/2013.
So he disappeared after 18/5.
18/5.
But that lady died around 15/5.
15. So his
16/5.
involvement, Lordship.
16/5 or yes, 16/5 or 15/5 or there were 3 days prior.
Yeah,
3 days prior would be 15.
50. So his involvement may be there, Lordship.
Maybe is that maybe is it's neither here nor there.
So he may not be the way.
But the surprising thing is that you are the husband, you are the mother-in-law, your grandchildren are there, your children are there, those 6-month-old or how many months old?
1 6 month, one,
5 years.
5 years, 1 6 months, 1 5 years.
Once 5 years and 1 6 months. And then you tell this group of ladies who come looking for the wife that she has gone to a maternal home. Why did you tell a lie?
So I am ignorant of the fact that such things happen, Lordship.
That such things happen.
This-
Where have you said that
that
such
my-
things
my,
happen?
My wife
Lordship,
died.
one more factor. For 3 days, daughter-in-law went missing, no endeavor to search. Even parents were not reported
Nothing.
and police was not informed, my lord.
Ah.
Nothing has been done.
No, according to them, she went to her maternal house, but then at 6 months baby, her 6 months baby. And then I think there is a evidence of some person who said that actually they had first stated that this disease had gone to Delhi.
Yes, my lord. There.
And then they
PW
changed their story.
Yes, my. Lordship, page 27.
Page 27. Correct, and the top is
My lord.
PW7.
And they're trying to bring up a story that the lady had an affair with Ranjit. But Ranjit, Lordship was fleeing after she was, her dead body was discovered. It's not a case, it's not their case.
That,
She-
yes, that
yes,
he disappeared
yes,
prior to that.
Yes,
So he disappeared only on 19th after
Yes.
the body was discovered.
No, that is, after body, he knew, he fully knew it well. That the dead body is in the doctor's septic tank. So he cleared
And the appellants have been convicted to undergo
30 to 34 minor, life.
life. That means remainder of life.
Yes, entirely.
How old is the mother?
70 years. Old.
She wanted
IPC,
75.
IPC, I don't have the IPC. Huh? After 14 minutes. Where's this mother-in-law people? You won't have to. Okay, right. Add Mr.
Yes, on.
A. Sharma, Learned Counsel for the appellants. Also heard Mr. B. Boyan, Learned Additional PP for the state of Assam. Yes, sir. This appeal is against the judgment dated 7/6/2019 passed by the Additional District and Sessions Judge number 2, Nagaon, in sessions T bracket 1, case number 10 bracket N slash 2015, by which the appellants have been convicted under section 302/34 IPC and sentenced to undergo a rigorous imprisonment for life with a fine of rupees
5,000.
with a fine of rupees 5,000 each, in default to suffer RI for 3 months. It says, it doesn't say RI for life, it just says imprisonment for life. Say imprisonment for life, huh? Don't say RI. Next paragraph. The brief, the prosecution's case in brief is that FIR dated 18/5/2013 was submitted by prosecution, no, by PW9. This is prosecution witness 9, huh? Bracket PW9 in short. To the effect that to the officer in charge, Samaguri PS, to the effect that her daughter Dipali Biswas had been married off to the appellant number 1 about 8 years back.
4 years.
Huh?
For PW9. 4 years.
No, come to page 4.
Lordship, page 31, evidence portion.
Acha, okay, about, had been married off to the appellant number one on 16/5/2013. No, no, not 65,
About 4 years
on,
before the date. It's written.
okay,
Page
but then
31.
this is wrong, then. I'm not- Translation, I think, is wrong. The page 4, it says 8 years. Let us see the records. What does
Yes.
the original record say?
Record.
Exhibit file.
Lordship, I'll exhibit and finding it. The file, madam.
Okay, right, about 12 years back, huh? Uh,
Lordship,
So-
it's a vernacular.
uh,
It's like overacting is there.
So what does it say actually?
Arts Mosor. Prior to it was written as 7, now it was overwritten as 8.
Okay, just forget, that is not the issue anyway. Whether when they married, that's not an issue. Okay,
Yes,
just
it was
whatever I
just
said.
a copy, it's not there.
The prosecution's case in brief is that an FIR dated 18/5/2013 was submitted by the PW9 to the OC Samaguri Police Station to the effect that her daughter
Just
Dipali Vishwa
see one thing. FIR is dated what?
18/5.
No, no, what I'm saying is. Fine. It will have 2013. See, 17. Okay. Just see, just give us the FIR, just see the.
Yes, it's an
just let-
18/5.
just let us see. What have I said?
The prosecution's case in brief is that an FIR dated 18/5/2013 was submitted by PW9 to the officer in charge Samaguri Police Station to the effect that her daughter Dipali
Had been
Vishwa
married off to the appellant number one. And that at the time of marriage, various gifts had been given. Full stop. However, the appellant number one, comma, appellant number two, and the elder brother of appellant number one had been torturing her daughter both physically and demanding dowry from her. The FIR further states that the above three persons had killed her daughter and packed her dead body in a gunny bag and kept it in the latrine situated behind the house of the appellant number one. Consequent to the above FIR, Samaguri PS case number 104/2013 under section 302/34 IPC was registered. Was registered and PW 11 was made the investigation officer, bracket IO, of the said case. After investigating the case, the IO filed a charge sheet against the appellants that is Shri Chandan Biswas, husband of the deceased, and appellant number two. Appellant number two, that is the mother-in-law of the deceased, and Prahlad Biswas, elder brother of appellant number one. What have I said? Last sentence.
After investigating the case, the investigating officer filed a charge sheet against the appellants, that is Shri Chandan Biswas, husband of the deceased, and appellant number two, that is the mother-in-law of the deceased, and Prahlad Biswas, elder brother of the appellant number one.
Having found a prima facie case under section 302/34 IPC against the above three persons. Next para, thereafter, charge under section wait. 304 is there also.
Yes, it was like, landed court below did not find materials.
Huh?
304B.
Huh?
Charges
No,
was
no,
under.
but then the charge sheet does not mention 304.
Formal charges-
304 is at page 83. It carries on till 86. Rakesh, you just get out 1 minute. Just get up. That's fine. Why,
Yes.
you see, it's not here.
Yes, no, it's not there.
But then at the same time, when you look at the charge has been framed under three heads.
Yes.
304B. 201. But then the charge sheet does not show 304 and 201. Let's look at the original. We'll just come out and another 304 and 201 is not there.
Not.
Okay, so what have I stated?
After investigating the case, the IO filed a charge sheet against the appellants, that is Shri Chandan Biswas, husband of the deceased, and appellant number two, that is the mother-in-law of the deceased, and Prahlad Biswas, elder brother of the appellant number one, having found a prima facie case under section 302/34 IPC against the above three persons.
Full stop, huh? It must be there in the order sheet. Let us see the
My lord.
trial court
Reading
order
of charge.
and the
4/3/15.
the framing of charge was done on 4/3/2015. 4/3/2015.
May I read, my lord? Accused Chandan Biswas, Prahlad Biswas and Josna Biswas are present. Hard, so both the sides for consideration of charge. Peruse the case record and relevant papers, particularly the postmortem report. On considering the entire record as well as of the learned, submission of the learned advocates of both the sides, it appears that there are prima facie cases under 304B, 302, 201, 34 IPC against the accused person above named. Accordingly, charge and so and so are formally framed against the accused
Okay.
person.
Right. Right. Next para. During the stage of consideration of charge, comma, the learned trial court framed two other charges against the appellants and Prahlad Biswas, as it found that no, what have I said?
During scope of consideration of charge, comma, the learned trial court framed two other charges against the
There's framed two other charges besides section 302/34 IPC. Comma, that is 204, no, 304B/34 IPC and 201/34 IPC. To which the accused persons pleaded not guilty and claimed to be tried. Full stop. The addition of the sections 304B/34 IPC and 201/34 IPC is reflected in the order sheet of the learned trial court dated
4/3/2015.
15/3,
4/3/2015.
4/3/2015. Next paragraph. During the trials, comma, 11 prosecution witnesses and no, 11 prosecution witnesses were examined, comma, besides recording the deposition of EO,
Executing officer.
executing officer 1/1. After considering the evidence recorded during the trial and hearing the parties. No, after, no, after, no,
after considering the evidence.
no, cut that for some, thereafter. The accused persons were examined under section 313 CRPC, in which they gave a blanket denial with respect to all the questions put to them. Full stop. The learned trial court thereafter found the appellants guilty of the offense. No, guilty of the, where is the,
Page 64. Fourth line from, in the first paragraph. last four
guilty,
lines.
guilty of section 302, guilty of section 302/34. IPC.
Fifth line, fourth line from of second paragraph, Your Lordship, last four lines.
Full stop. The appellants, no, the accused Prahlad Biswas was however acquitted from the charges, from all the charges framed against him, including section 302/34 IPC. The appellants were also acquitted of the charges under section 201/34 and 304B/34 IPC. Correct?
Only 201, 304B.
That's what I'm saying.
Yes.
Full stop. On conviction of the appellants under section 302/34 IPC, the appellants were convicted to undergo life imprisonment with a fine of rupees 5,000 each, in default to suffer RI for 3 months. Next paragraph. The learned counsel for the appellant submits that they were never aware that the body of the deceased had been stuffed in a gunny bag and was in the latrine of the house in which they were living in. He also submits that it appears that Ranjit Biswas, who is a relative of the appellant number 1 and who had been living with them, had been having a relationship with the deceased, as he had fled away on 19 May 2013 after the body of the deceased had been discovered. Full stop. That's all. Full stop. Next paragraph. The counsel for the appellant submits that the prosecutor, that the conviction of the appellants was made only on the basis of circumstantial evidence which has not been firmly established. He submits that the circumstances relied upon by the learned trial court do not form a complete chain to prove the guilt of the appellants in the death of the deceased. In this respect, he has relied upon the judgment of the apex court in the case of Dash versus Dash, reported in 2006, 10 SCC 681. The learned counsel also relies upon the judgment of the apex court in Dash versus Dash, reported in 1996, 10 SCC 193, in support of his submission that unless circumstantial evidence is conclusive in nature, pointing only towards the guilt of the accused, comma, the accused would have to be acquitted of the charges framed against him. He also submits that there being no proof of the hand of the appellants in the death of the deceased, comma, two views are possible when the evidences adduced are taken into account, are taken into reckoning. Full stop. He submits that in terms of the judgment of the apex court in Dash versus Dash, comma, reported in 2006, 13 SCC 516, comma, the views favorable to the accused should be accepted by the court, when the other view, when there are two views, comma, one being unfavorable to the accused. That's all. Next. Ms. B. Bhuyan, the additional, no, before that, you decide. The learned counsel for the appellant thus prays that the impugned judgment should be set aside and the appellant should be acquitted of the charge. Of the charge under section 302/34 IPC. Next paragraph. Ms. B. Bhuyan, the learned counsel, the learned additional PP, comma, on the other hand, submits that the evidence recorded in the learned trial court clearly goes to show that the appellants were guilty of the crime in causing the death of the deceased. She submits that though the entire case is built on circumstantial evidence, comma, the circumstances and that the circumstances definitely point towards the guilt of the accused and the facts stated in the evidence clearly prove that the appellants were lying to escape the liability of the charge of murder. She submits that the doctor's evidence shows that the deceased had died 3 days prior to the filing of the FIR, comma, that is on 18/5/2003. And it was inconceivable for a mother to leave behind a 5-year-old and 6-month-old child to leave behind a 5-year or 6-month-old children and go away to her maternal house without taking the children. She further submits that the evidence of PW 2 and 3 shows that the appellants tried to, no, the appellants lied to the public with regard to the absence of the deceased in the house. While the fact of the matter was that the dead body of the deceased had all along been hidden in the latrine of the appellant's house. The additional PP further submits that the evidence of PW 7 is to the effect that the appellants did not allow the neighbors to enter the house of the appellants, which would imply that they were scared of the discovery of the body of the deceased. She submits that the death of the deceased having in all probability, in all having occurred in all probability within the confines of the 4 walls of the appellant's house, the burden of proving the said fact by anyone living outside the 4 walls of the said house would be extremely difficult. And by taking into account the circumstantial evidence, the burden of proving, then by taking into account the circumstantial evidence, it showed that the death of the deceased had been caused by the appellant. Further, the burden of proving of what happened within the 4 walls of a house should be, would lie on the persons living within the 4 walls of the said house. However, the appellants have not given any explanation with regard to the evidence of finding the dead body of the deceased in their latrine during their examination under section 313 CRPC. She accordingly submits that there being a clear-cut case of murder which has been proved by the lies and actions of the appellants, the impugned judgment passed by the learned trial court should not be interfered with. We have heard the learned counsels for the parties. The evidence recorded by the prosecution witnesses goes to show that the deceased and the appellant number one had married about 4 years before the death of the deceased, comma, that is in the year 2009. Nine. Pusta. Two male children were born to them, and at the time of the death of the deceased, the age of the elder child was 5 years and the age of the younger child was 6 months. The appellant number two is the mother-in-law of the deceased. Person. PW 9, who is the informant and the mother of the deceased, in her evidence states that the appellant had been torturing the deceased for dowry. Pusta. On the day of the occurrence, that is on 13/5/2013, some neighbors of the appellant number one informed her over phone that her daughter had died, had died, and that her grandchildren were crying. She reached the house of the appellant number one around 10/11 a.m. and saw many people had gathered in the said house. Thereafter, the villagers and the village headman arrived there and found a dead body inside a gunny bag in the septic tank, which was located behind the house of the accused person. Actually, it is not latrine, it is septic tank. But somewhere it is a latrine also. They have said police were called and the police and the villagers took out the dead body from the septic tank. And took out a dead body, no, took out a gunny bag from the septic tank. When the gunny bag was opened, the dead body of the daughter of PW9 was found. Accordingly, an FIR, which was written by a person from the said village, was submitted by PW9 after putting her thumb impression on the same. Next para. The evidence of PW1 who is the Gaon Bura bracket village headman, correct? That close. Is to the effect that he knew all the is to the effect that he knew the appearance and the deceased. he states that the deceased was a member of the Mahila Bandhan group. As the deceased was to make some payment to the Mahila Bandhan group, comma, the master of the Mahila Bandhan group urged the secretary to search for the deceased as she was not present in the meeting. Thereafter, about 10 women of the Mahila Bandhan group informed PW number 1 that the appellant number 1 had killed his wife Dipali, and hid her body in a latrine. PW1 thereafter went to the house of the appellant number 1 and found many people gathered there. He also sensed a foul smell coming from the latrine. So thereafter, they saw a gunny bag in the septic tank. He informed the police about the matter, and the police, CRPF and circle officer arrived at the spot. The police lifted the gunny bag from the septic tank, and on opening it, they found the dead body of the deceased Dipali Biswas. The inquest report was prepared by the circle officer, and the police recorded his statement. He also states in his cross-examination that the appellants were living together with the deceased and that he did not know how the incident took place. Next paragraph. The evidence of PW number 2, PW2, is that in the Bandhan group meeting, meetings, the deceased had not been coming, had been absent. Even after her return from a visit to her maternal house. The person that the Bandhan group members address as Sir, SIR, asked the members of the Bandhan group, Mahila Bandhan group, to go to the house of the deceased Dipali around 10 a.m. All the members of the Mahila Bandhan group, that is Basanti Chamulia, Maya Gawala, Sumi Chamulia, Rita Samulia, Padma Naya and PW2 went to the house of the appellants. On arriving there, they inquired about the deceased. The appellant number 2 informed them that the deceased had gone to her maternal home. Then PW2 and the group of ladies saw the children of the deceased and they asked the appellant number 2 as to why the deceased did not take her 2-year-old and 6-month-old children with her if she was visiting her maternal home. Further, the group of Mahila Bandhan persons, no, the group of persons belonging to the Bandhan group were of the view that the deceased might be hiding in the back of the house to avoid returning the loan of rupees 10,000 taken from the Bandhan group by the deceased, which was being repaid in installments. Accordingly, on searching for her in the back of the house, they became aware of a foul smell. Thereafter, they saw the manhole of the septic tank half open and foul smell was coming out of the septic tank. They saw a gunny bag inside the septic tank and accordingly called the neighbors. When people prodded the bag to know what was inside the bag, it seemed to be a human body inside the bag. People suspected the body to be the deceased. The village headman informed the police, and after the police took out the gunny bag, the dead body of the deceased Deepali Biswas was found inside the gunny bag. The dead body was sent for post-mortem examination thereafter. In her cross-examination, PW2 states that a boy named Ranjit Mandal had been staying in the house of the accused persons and that she did not know if the said Ranjit Mandal had any love affair with the deceased Deepali. She also states that she did not notice any injury mark on the body of the deceased. The next para, the evidence of PW3 is to the effect that he saw many people gathering in the house of the appellants, and on reaching the place he found that the police were opening a polythene bag wherein the dead body of the deceased was recovered. Full stop. In his cross-examination, PW3 states that the bag in which the body of the deceased was found was stained with blood, and that he did not see any injury mark on the dead body. Full stop. Next paragraph. The evidence of PW4 is to the effect that he saw the dead body of the deceased, which was being examined by the police. The evidence of PW5, who is the doctor who conducted the post-mortem examination of the deceased, is to the effect that, in his opinion, all the injuries were ante-mortem in nature. And number one, all the injuries are ante-mortem in nature. Number two, approximate time and death was prior to 3:30. It is here, at page 21. I'm putting it there, page 21 and page 22. Okay. The evidence of PW3 is that on Friday morning, when he heard the younger son of the deceased crying, he came to the house of the appellants and asked the appellant number 2 why the baby was crying so much. The appellant number 2 replied that the deceased had left the house and she did not know where she had gone. And that was the reason that the baby was crying. PW6 also states that around 10 a.m. of the following day, that is on Saturday, the woman of the Bandhan group came to Dipali's house, inquiring why Dipali did not go to work. The woman searched for Dipali and found a gunny bag in the septic tank in the back of the house of the appellants. Some boys were called from the neighborhood and they removed the lid of the septic tank. Acha, they have interplayed with latrine and septic tank. They have same. They found the gunny bag contained some heavy object. The village headman was informed, who in turn informed the police. After the gunny bag was taken out from the septic tank, the dead body of Dipali was found in it. Further, the dead body was stinking, and the same was taken away for post-mortem examination. The evidence of PW7 is that On the day when the body was recovered, body of the deceased was recovered, a group of women had come to the house of the appellants to inquire about the deceased as she did not attend the meeting of the Bandhan group. The appellants on being asked on being asked the whereabouts of the deceased, were first told that she had gone to Delhi. Later on, they were told that she had gone to her maternal house. Not being convinced, not being convinced by the reply, the woman entered the house in order to search for Dipali. The appellants did not allow them to do so. However, when the woman looked for Dipali around the house, they saw a gunny bag in the septic tank. The police were informed, and on the gunny bag being taken out from the septic tank, they found the body of the deceased, which was stinking. The evidence of PW 8 is that she was a part of the group of women of the Bandhan group who had gone to look for the deceased Dipali. Her evidence is in the same line as the evidence given by PW. Two. The PW 9 evidence we have already stated, no? Already done, no? The evidence of PW 10, who is the VDP secretary of village Udmari, is to the effect that he was informed that a dead body had been found near the house of the appellant. On going to the place of occurrence, they found a gunny bag in the septic tank, and on removing the same, the police found the body of the deceased. Next para. The evidence of PW 11, who is the IO of the case, is to the effect that the dead body of the deceased was found inside a plastic bag, which was kept in the latrine, which was kept in the septic tank near the house of the appellants. After examining witnesses, and recording the evidence of various other persons. He submitted the charge sheet. He submitted a charge sheet showing that the person who stayed with the appellants, that is Ranjit Biswas, as an absconder. He also states in his cross-examination that as the incident had taken some days ago, no blood was found. So he also states that he also denies the suggestion that Ranjit Mandal had committed the crime. He also states in his cross-examination that after the marriage, the appellants had been torturing the deceased. He also denies the suggestion that the appellants were not involved in the incident. Next para, the evidence of executing officer 1 is that he went to the house of Shri Ranjit Biswas for execution of the proclamation and attachment order. A document. A warrant of attachment. Would be order. Proclamation and warrant of attachment order. Proclamation and warrant of attachment. However, he could not locate the accused Sri Ranjit Biswas. Next. As can be seen from the evidence adduced by the prosecution witnesses, it is apparent that the body of the deceased had been lying in the septic tank of the appellants for quite some time. The evidence of PW5 bracket doctor states that the approximate time and date of death was prior to 3:30 AM of 18/5/13 as rigor mortis, and that 3 days prior to 18/5/2013 as per the inquest report. Thus, it can be safely assumed that the body of the deceased which had been recovered from the septic tank must have been there in the septic tank for a number of days, as it is inconceivable that the dead body of the deceased would have been dragged from somewhere else outside the premises of the house of the appellants and into the as it is inconceivable that the deceased had died in some faraway place and brought into the latrine and brought into the septic tank. Of the appellants. Full stop. In fact, in normal circumstances, the body would have been kept hidden by removing it from the near presence of a house occupied by persons. In this particular case, the foul smell coming out from the dead body, the foul smell coming out from the from the what pit was that? Septic tank was noticed by the witnesses, and the same would have been noticed by the appellants also. Next para. The evidence of PW5 also shows that the cause of death of the deceased was due to a result of head injury leading to coma. Full stop. Though though there is nothing to prove as to what weapon was used for causing the death of the deceased, the behavior and lies of the appellants indicates that they were responsible for the death of the deceased. The evidence of the witnesses show that the appellants were not allowing the group of ladies belonging to the Mahila Bandhan group to enter into the house, and had also lied to them with regard to the whereabouts of the deceased. The appellants had first stated that the deceased had gone to Delhi and thereafter changed their story, stating that she had gone to her maternal house. However, due to the search carried out by the ladies of the Mahila Bandhan group, and due to the half-opened manhole of the septic tank, the gunny bag containing the body of the deceased was sighted. Full stop. The fact that the appellants had lied with regard to the whereabouts of the deceased is quite clear. keeping in view the fact that the young children of the deceased were apparently in the house of the appellants. Full stop. A 6-month-old child would still be nursed by a mother. And the absence of a mother, even for a day, would have been acutely felt not only by the child, but by the persons who are supposed to love the said child / baby. However, despite the absence of the deceased from the paternal home, from the what do we call it? Matrimonial home, no attempt had been made by the appellants to call her home or make any queries with regard to her whereabouts, knowing fully well that she lay within a gunny bag inside the septic tank. Behind the house of the appellants. In the case of so-and-so was so-and-so, 2006 10 SEC 681. The apex court has held that in a case based on circumstantial evidence, the circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. Full stop. Further, those circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused. Full stop. The circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused, and they should be incapable of explanation on any hypothesis other than the guilt of the accused, inconsistent with their innocence. Full stop. The apex court further held that if an offense takes place inside the privacy of a house, and in such circumstances where the assailants have all the opportunity to plan and commit the offense at the time and in the circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused, if the strict principle of circumstantial evidence, as noticed above, is insisted upon by the courts. Full stop. A judge does not preside over a criminal trial merely to see that no innocent man is punished. Full stop. A judge also presides to see that a guilty man does not escape. Both are public duties. Full stop. In the present case, comma. No, no, in view of the law laid down by the apex court, comma. The law does not enjoin a duty on the prosecution to lead evidence of such character, which is almost impossible to be led, or at any rate, extremely difficult to be read. Full stop. Where an offense like murder is committed inside the secrecy of a house, the initial burden to establish the case would undoubtedly be upon the prosecution, comma. But the nature and amount of evidence to be led by it to establish the charge cannot be of the same degree, comma, as is required in other cases of circumstantial evidence. Full stop. Next paragraph. In the present case, it is an admitted fact that the appellants have been living all along in the matrimonial home with the deceased. The evidence also shows that the appellants had been lying with regard to the whereabouts of the deceased with the members of the Mahila Bandhan group. It is also a fact that the body of the deceased was found in the septic tank belonging to the appellants, and that death had occurred about 3 days prior to the recovery of the body. It is also a fact that there was a foul smell coming out from the septic tank. It has also come into evidence that the appellants were not allowing the woman of the Mahila Bandhan group to enter the house. Keeping in view the above facts, comma, the apparent nonchalance and non-incidence of the appellants with regard to the absence of the deceased on the ground that she had was visiting her maternal house without her young children, comma, in the opinion of this court, leads us to the conclusion that there is a complete chain of events, complete chain of circumstantial evidence proving that the appellants were aware that the deceased had died, and that they had hidden the body. Sir. The evidence of the doctor having also clearly proved that the deceased had died due due to injuries leads us to the conclusion that only the appellants could have caused the death of the deceased within the secrecy of the four walls of their home. That's all. On considering all the above facts and the reasons given in the foregoing paragraphs, we do not find any ground to interfere with the judgment, with the impugned judgment passed by the learned trial court. The appeal is accordingly dismissed. Then what about the IA? In view of the order passed in the main appeal, the IA is also accordingly disposed of.